Okay, three voice material. This is all colloquy. There is no Q&A in here, and we're going to be reading this at about 2:10, 2:20. And we'll identify for you. I am defense attorney, Mr. Towman.
The court. I am plaintiff attorney, Mr. Platt.
Mr. Towman begins on the record. Objection, irrelevant. This motion is limited to Miranda.
Yeah, he's not doing anything about the gun. Testified.
That's fine.
Testified about this exact movement in the back seat.
I was following up on an area of cross-examination. I didn't think it was relevant either, but I was following up with some questions.
Well, that was covered in your examination.
It was only for the purpose of showing they were detained.
That's fine.
Okay.
I think that is adequately covered in the preliminary transcript as well. So I just following up on a couple questions I had.
Sometimes we have to plow through this. When I first saw this yesterday, I thought this was the transcript of the Hernandez file, but it is the preliminary.
The preliminary hearing transcript is about 450 pages longer than the Hernandez trial.
Okay.
There is a length in numbers, Your Honor.
I've got no further questions, Your Honor.
Very good.
The rest will be covered, I think, in what the court will read in the transcript.
Thank you, Officer Lazar. You may step down. I'm going to take both these under submission too. I'm glad there are no football games on this weekend.
Judge, there were several other motions relating to the stop, including failure of Miranda, securing evidence, failure of Miranda, the illegal detention, the illegal arrest, and so forth. The one issue that appeared not to be raised that I thought should be raised was the question of stopping for a misdemeanor or arresting for a misdemeanor out of the presence. That's the only one we are asking for at this time. Obviously, the court is going to review the others.
I have no problem if the court, including the defense counsel, includes that as grounds or basis in its motion. I think that the testimony covers that as well as it does the remainder of the motions, and I think that there is an answer to that it is going to be the result in the same ruling by the court, but I don't have any problem having that included as a ground at this point.
Very good. What other limine matters? The photographs. Have you gotten together to show Mr. Tallman what photographs you plan on introducing?
Yes, Your Honor. I got the same packet that I used at Mr. Hernandez's trial.
I have not received the autopsy pictures.
You have?
I have not.
The same packet as yesterday?
No.
Maybe what I need to do, Lenny, is to get, when Sanford came back next week, to have him run down that particular group of photographs.
Okay.
I got several photographs, Your Honor, that Mr. Towman is taking a look at. I think there is maybe 1, 2, 3, and 4. There is 4 of them that have marked on the back as people's 1, 2, 3, and 4 that are from Mr. Hernandez's trial that I would seek to use in this matter as well.
Number 1, it is an autopsy photo.
If I can take a look briefly, Your Honor, I can explain to the court the necessity I feel for it. That particular photograph, the area across the shoulder or the chest, is an area that Dr. Lawrence will be testifying to is a tire mark or mark from a tire, the victim being run over. I think that that particular photograph is, in talking with Dr. Lawrence, necessary to his determination and explanation of some of the injuries, in particular that area. The body itself does not have any broken bones, broken ribs, or anything that one would normally expect from a person being run over, which puzzles Dr. Lawrence. And that photograph, as well as the photograph of the individual laying in the field with his arms behind his back, and the photograph of the side of the head altogether, provide Dr. Lawrence with a basis for the explanations to the injuries and the type of wounds that were inflicted on the victim. And I realize that they have some prejudicial effect in that there are some areas of the body being depicted in fairly graphic form, but I do not believe that they are so prejudicial to outweigh their probative value, and I would ask to use that.
You are saying Dr. Lawrence referred to these in the trial of Jesse Dale Hernandez to explain the use of the car to run over the victim by these photographs?
Yes.
Judge.
And the one with the side of the head also. What is the significance of the side?
The one to the side of the head, that injury is explained by Dr. Lawrence, according to Dr. Lawrence, in explanation of a tire spinning, a brush-type abrasion pulling the skin and the hair away from the head.
Then the one showing this People's Exhibit number 3, showing it is an autopsy photograph. What's the...
That, if any, I would see the court excluding. There was more of an issue in the Hernandez trial regarding Mr. Hernandez's activity, and whether there was 1 or 2 cuts on the neck, or whether there was any internal indication of any cut on the neck, which Dr. Lawrence indicated there was not. That photograph went to that portion of the testimony.
I don't think we need 3. 3 shows the full face with the cut on the neck, and that can be shown, and it is a close-up.
I can withdraw that. I don't have any problem with that. That was necessary, as I indicated, more in relation to an issue of Mr. Hernandez's participation rather than Mr. Frederickson's or Mr. Mahoney's.
And what about the Exhibit 4 showing the victim in the field
That
with hands behind his back?
That position in the field with the arms behind the back and the chest in a very concave position is what Dr. Lawrence looked at. And finally, concluding that the victim had in fact been run over. He referred to that photograph in making that determination based upon a difference in the positioning of the body at the autopsy when he was placed on the table in the autopsy room, his arms in a different position, still behind him, but still in a different position. That did not show the concave nature of the chest, which is one reason why Dr. Lawrence indicated that he did not make the conclusion at the initial autopsy that there was obviously a person being run over. And then after looking at the photographs and being advised of the additional information, it became very apparent to him that he should have known that initially, that it is very apparent in that photograph when you see it.
3. 3 is going to be out. What are your comments as to 1, 2, and 4, Mr. Tomlin?
Judge, first of all, Mr. Platt doesn't claim, and I think the court's brief look at the photographs from that it should be clear that they are obviously terribly inflammatory pictures. My understanding is the justification for bringing all 3 of those in because it shows support for the subsequent determination by the pathologist that he was run over by a vehicle. Well, look, here the photos show it, and this is why it was difficult to determine. Whatever, that's not an issue. I'm prepared to stipulate that the victim was run over by a vehicle. I'm prepared to stipulate, Lawrence has testified previously that he screwed up on the first one and that it has or was an amateurish mistake, that any pathologist would have recognized it right away as a vehicle, and he still to this day does not understand how he did not. And the only reason he continues to believe that he did not at first identify the marks and the different information he had as tire marks is only because he has his original autopsy, which doesn't have it on there. The determination is one that an expert can make. That is a pathologist. It is not an issue. The question of why he made the mistake is not an issue. I mean, it is not, well, wait a minute, you didn't say that the first time, therefore it isn't true. The thing he is attempting to introduce those for is not an issue. I'm prepared to stipulate away all the reasons for the photographs. Only thing left is they are not inflammatory.
You are not going to question Dr. Lawrence. The results of the first autopsy didn't mention anything about an automobile?
No.
But the information concerning...
If the question is getting these photographs in or not questioning him about the first time through, he didn't say anything about the tire marks. No, not at this time. Now, obviously, I don't tend to know exactly how the case is going to come out as it comes from the testimony, and that may change. And at that point, Mr. Platt may have personal justification for the photograph. We are in limine, and we can eliminate the need for these photographs, and they are extremely inflammatory. And so under 352, when you weigh the process, there is nothing on the other side.
But the difficulty we get into there is how the police found out about the automobile was this reenactment.
Well, he can say that. I'm not going to challenge that.
But then what you were doing, Mr. Tomlin, you were stipulating that the reenactment was valid by simulating he was run over by the automobile, because there was no other source of that except your client's reenactment of the scene.
We haven't gotten to the reenactment yet.
Oh, the physical movements of the reenactment are admissible as to the statements made by particular individuals. That's what we haven't gotten to yet.
That's true, but that is very much an issue. And the question of whether the statements and who said what and the information that's going to be arguably presented before the jury is reliable enough even to get before the jury is very much up in the air. I mean, I'm not prepared to concede that. We still have to talk about that. Judge, all I'm saying is we now know why Mr. Platt feels those pictures should come in. Before the pictures come in, let's see if it is an issue. If it is not an issue, all I want to have is an agreement from the court that obviously they will not come in and obviously no showing.
What about the murder by torture special circumstance?
That hasn't been presented.
Huh?
Mr. Platt knows his case well. He tried this case before.
Except there were no specials against the juvenile.
Mr. Platt is standing here 20 feet away, Your Honor. I mean, the court says maybe it can come in for this and that, but Mr. Platt knows why he wants it in. They are not very pleasant pictures, Your Honor, and if there is a basis for keeping them out, if there is a way consistent with allowing Mr. Platt to present his case, keeping those pictures out, then that's what we ought to do. I think that's fair, and I think that's reasonable.
Let me see the other photographs. Do you have any other photographs of the victim?
I don't believe so, Your Honor, no.
Well, how many photographs of the four that you had marked and presented in Hernandez, how many of the victim were included in the package from the technician?
I'm sorry, I don't understand your question.
Well, you had more than 4 pictures of the body?
Yes,
How many did you have?
including the autopsy photographs.
Everything.
Rough number, I would guess probably 30 or 40. 30 photographs easily of the various aspects of the autopsy, and another 4 or 5 of the victim at the scene, I would imagine. Those photographs that I have offered to the court, I have selected out of the photographs that I felt either had no relevance to a point that I needed to prove, or I didn't feel I would be able to get in because of their prejudicial effect. I think certainly the 3 photographs I'm offering are unpleasant photographs. The whole crime is an unpleasant crime. But I'm not going to be kept from getting in all the evidence on the crime. The question is whether probative value is outweighed, and I don't think it is.
I don't think it is. I think they have probative value on the torture as well. I think the reason they were used at Hernandez's trial is because of Dr. Lawrence's testimony, and they were very important. The manner in which the victim was killed, the things that were done to him all become very important down the line. And part of it is because of the torture aspect of it, and I think that those photographs, those 3, while certainly they are unpleasant, I think are within the tolerable level to be permitted before the jury. Let me see within the rubber band. There is no objection to this group, apparently?
No, none of them depict Mr. Harrison's body.
Those photographs all deal with either lineups, photographs of the car, some of the ID items that were found at the scene away from the area where the body was.
Do you have any photographs of the victim after he was cleaned?
No.
Do you have your automobile?
Those are photographs, I believe that. My understanding that those are photographs that were taken after he was cleaned. That's the best that they were. Apparently the body was covered with a lot of dust and dirt, and that's the photographs that were taken. To what extent there was a cleaning of the body.
I'm going to reserve ruling on those until it becomes an issue. I don't know about the stipulation. I mean,
Well,
to stipulate that, actually, from the reenactment, it is my understanding your client was the driver of the vehicle when they placed the head of the victim under the car and then drove over him a couple times.
Judge, we can reserve your ruling on it if you would like until after you have read Mr. Moulton's testimony and made your ruling on the reenactment. In my opinion, everything is going to come in. Certainly, some direct statements from Mr. Fredrickson's mouth about his activity are going to come in. And perhaps we can address the issue of whether there is going to be a stipulation on it after that, which might put it in the proper light for Mr. Talman or myself to evaluate whether we want to enter our stipulation like that.
I think to put it in,
if the court is going to admit it for torture, that's one thing.
that's what I'm saying. The pleadings are that the special circumstance of torture, and now the Supreme Court has said that this 1978 amendment is out and it has to be an intentional killing, and that they are also relevant on the driving over him.
See, I don't know what the court is suggesting. I have an autopsy report. I don't understand what the court's concern is. I have an autopsy report that doesn't have anything in there about driving. Is the court suggesting that my argument is that although he didn't put it in there, that he did in fact know, or he was waiting for an opportunity to, or for someone to make a reenactment, for somebody to say it was a tire and wait until the reenactment? I don't know what the court is having a problem about on my stipulation. The autopsy doesn't have anything about the driving.
I know, but then you're going to stipulate that they drove over the victim's body.
How am I going to argue that they didn't? I mean, I don't want to try this case. I don't want to try this case in limine, but I'm a little lost what the court is suggesting.
Well, the explanation as to the way the one side, I guess it is the left side of his head, and the way the hair is removed is apparently from spinning tires on his head. They only got that information through your client at this reenactment, which is going to make that reenactment, if you stipulate, yeah, the only way they knew about this is from my client, and now the doctor is saying this.
No, after.
After, but you are almost stipulating to the total validity of this reenactment. That was my point. I mean, you are saying with this reenactment at the jail in front of these 3 people, I'm stipulating that that happened because that's the only source of this running over by the car.
Well,
It makes it inherently credible. If you stipulate to that ultimate fact that they ran over him with the car, when the only source of that is from your client, they're going to just believe the entire reenactment scene, or do you believe they're going to believe it anyway?
Judge, the autopsy doesn't have anything about a tire. Between the autopsy and Lawrence's subsequent statement that he was run over, he discovered he was run over, the reenactment, okay? I've indicated I indicated yesterday that there were going to be some things to look out for in terms of where Lawrence got his information.
Uh-huh.
What I'm indicating is I'm prepared to stipulate, if it makes the difference between those photographs coming in, prepared to stipulate he was run over, because I'm going to have an expert testifying he was run over anyway. I'm not prepared to stipulate that Lawrence didn't know. Lawrence is going to testify to that.
But you are not going to challenge his conclusion that the marks on the head are skid marks from the car and that the marks across the torso of the body are from the tires. Is that what you were saying? You are not going to challenge his conclusion? Because if you challenge that conclusion, then these photographs, the relevancy is going to outweigh.
It is clear, I agree.
The unpleasant effect they are going to have.
I agree with what the court is saying.
And so if you don't challenge that, I am inclined to keep these photographs out, especially if the victim in the field, unless you want to raise a different theory for them, it is just for that issue.
No, Judge, I would not need the photographs, I believe, if there is no challenge to the conclusion that the victim had his head run over. That's what the injury on the side of the head is from, that the marks across the chest are, in fact, tire track marks. The portion that I would not be entering into the stipulation, I would still question Dr. Lawrence on his initial conclusion before the reenactment, which didn't include anything about being run over.
Uh-huh.
They put the reenactment on and then bring Dr. Lawrence back to say, after the reenactment, you were told about the reenactment. Did that change your mind? And I agree with what the court's interpretation is. What that does is creates a very...
Let's wait to see how Dr. Lawrence's testimony, if you are willing to stipulate he was run over, and if that's the only theory the DA is presenting, I'm not going to have these pictures in.
Your Honor, that's the only basis that I feel that I can legitimately ask the court to include those photographs on. Torture, I can make the same argument, but I don't think I need the photographs to do that. Once we get over the hurdle of the reenactment of whether or not he was run over, you know, the reenactment is going to, in my opinion, lay out the torture, not the photographs. I can argue the torture aspect without the need for the photographs.
Okay, then here is your photographs back. We are not going to use them if there was a stipulation he was run over on the chest and the head.
All right, here's the way I see this happening. They indicated they are going to introduce them for one basis. As I say, we have a ways to go before we get there because we have statements and so forth we haven't resolved and things such as that. If it becomes an issue, in other words, if Lawrence's testimony that they were run over...
If you think you can challenge that.
That's right.
And that challenge would outweigh these photos, you want to change your mind on that.
Fine, then the photos come in.
Judge, I won't do anything. I will have them now and throughout the whole trial. They aren't going to be made use of until Dr. Lawrence testifies, and if there is a challenge at the point he testifies, then I will again, before I introduce them, before I use them, the jury, make an offer to use them so the court and defense counsel is aware that I had seen something I want to make the use of them for, and we can address whether I want to use them then or not.
Okay.
But I wasn't certainly make any use of them until the use arises, and then we can, when Dr. Lawrence testifies, enter the stipulation at that point, so it is in the proper sequence of his testimony.
Okay, we can do that. I'll keep the photographs out.
That's fine.
Fine.
Any other motions?
Your Honor, these 4 photographs haven't been marked by this court. You want to have them marked?
They have been sufficiently identified. They have a Superior Court number 1, 2, and 4. I already said 3 wasn't coming in, and they were on the Hernandez case.
They are under the exhibit number 33836.
They are sufficiently identified for the record. Any other matters?
In the statement taken from Mr. Fredrickson, there is no advisements that if Mr. Fredrickson wants to stop questioning, he may do so at any time. I'm moving that that statement not be admitted because he was not advised of that fact.
Do we have a transcript of that I can review?
Yes.
Could I have a copy of for the weekend? Now, what transcript did you provide me yesterday and were going to provide me yesterday, Mr. Platt?
I provided 2 copies, one of the 2 originals, one of Mr. Moulton's statement and one of Mr. O'Connor's record statements.
My clerk, give me those.
I thought you also had Mr. Wright's statement.
No, I didn't. Wright didn't give a recorded statement.
Oh, that's...
Okay.
Wright didn't want to. Sanford transcribed the statement that he gave him before that. He testified at the prelim. When I went out there, he wouldn't talk. Your Honor, I can provide the court with Mr. Fredrickson's original.
Very good.
That leaves me without a copy, and I won't need it over the weekend. But it is the original, and I will need a copy of it back so I can have it during the trial.
May I approach the clerk for just a moment? I would like to have marked these that are documents I received from Mr. Platt containing priors and special circumstances.
Penalty phase.
That includes several prior police reports and so forth from several prior offenses alleged against Mr. Frederickson. Toward the end, there is also a series of prior robberies and so forth by Mr. Mahoney. I've included them because they came in a package I received.
This is the district attorney complying with the notice to the defense counsel of evidence that will be introduced at the penalty phase?
Yes.
Very good.
Your Honor, I got a copy for the court too. I had prepared separately. The court indicated.
I said I wanted something on file so there is no difficulty. If we get to the penalty stage, there would be no difficulty as to what the notice is to Mr. Tomlin. It looks thinner because I imagine that's because you took Mahoney's stuff out.
This only includes stuff from Mr. Frederickson.
Why don't you look at that?
Let me look at that.
Do we have any other matters?
Your Honor, I've got 3 transportation orders. I don't know if you want to sign them now or hold on to them.
Just for the witnesses?
Yes, I put them on the date of the first day of the trial, the 9th.
We don't want that. Why?
I can have that portion amended to when we get some idea as to how well we are progressing with the jury selection and the evidence. But at least I'll have them on order. That's as to Frederickson, as to Mr. Moulton, Mr. O'Connor, both who apparently are in San Francisco City Jail, and Mr. Wright, who is in Folsom State Prison, I believe.
We've talked about a derogatory comment.
Yeah, the derogatory comment is out.
I'll be discussing that with Mr. Platt. I think most of the rest involved either rulings that were to be made by the court on Tuesday or a review of the transcripts concerning Moulton's. I think we are going to have to go through further motions on that, and it may be we won't be able to do that until we have those witnesses here, but we'll discuss that on Tuesday.
Okay, is that it?
That's it.
Yes.
Court's recessed
Until?
Tuesday morning at 10 o'clock.
Okay, that was about 22 minutes and most of it over 200.